Welcome to Gesture Politics video on compelled speech and the forced use of preferred pronouns. I think of the First Amendment free speech clause as a coin. On one side, of course, is the prohibition on the government, with few exceptions, of preventing us from speaking. And on the opposite side is a prohibition on the government, again with few exceptions, from compelling us to speak. Under the compelled speech doctrine, the government is prohibited from forcing an individual or group of individuals to engage in speech that they disagree with. If you think about it, the prohibition on compelled speech is fundamental to free speech. Free speech would be a hollow right if the government could compel you to speak in support of issues you disagreed with, or even compel you to engage in speech that adheres to or even implicitly promotes a government's message that you do not support. And yet, this is what the governments, primarily the states, but in some cases the federal government, has consistently done throughout our history. In fact, it wasn't until 1943 in West Virginia State Board of Education v. Barnett that the Supreme Court even addressed compelled speech. In this case, the court held that West Virginia's requirement that students attending public school must salute the flag while reciting the Pledge of Allegiance was an unconstitutional infringement on their First Amendment free speech rights, because it compelled them to engage in speech that they did not agree with. The fact that the two children expelled because they wouldn't salute the flag and say the Pledge of Allegiance were Jehovah's Witnesses, the court found to be irrelevant. They didn't decide this on a free religion basis, but on a free speech cases applicable to all. I also want to emphasize that the court did not rule that you cannot say the Pledge of Allegiance in school, merely that you cannot compel people to participate in saying the Pledge of Allegiance. The Supreme Court again affirmed its position on compelled speech in 1977 when it decided Woolley v. Maynard. In this case, a man served 15 days in jail for taping over the New Hampshire state motto on his license plate, quote, "Live free or die." The Supreme Court found that the New Hampshire law making it a misdemeanor to obscure the state motto on a license plate was compelled speech in that it forced the person to promote an ideological message that he disagreed with. In 1995, the Supreme Court again addressed the compelled speech issue in Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston, when they ruled that the government was unconstitutionally engaging in attempts to compel speech by forcing the parade organizers to accept the gay and lesbian group as participants in their parade, because it sent a message that the parade organizers did not want to send. Key to this line of cases is that the government is attempting to compel a person or persons to engage in speech that implicitly or explicitly supports a message the government wants to send, but the participants don't want to support. So what does all this mean as far as state compelling teachers and professors to use preferred pronouns in public educational institutions? Well, the majority of cases so far have come down on the side of that's compelled speech, including the Sixth Circuit Court of Appeals. And I believe that's the correct interpretation of Supreme Court precedents up to today. However, there has been a minority of district court judges and some state court judges that have held that requiring teachers and professors to use the preferred pronouns of their students is not compelled speech. The Seventh Circuit Court of Appeals has sided with this group, resulting in what's called a circuit court split. What does this mean? Well, it means that in the Sixth Circuit of Kentucky, Michigan, Ohio, and Tennessee, requiring professors and teachers to use preferred pronouns is an unconstitutional compelling of speech. While in the Second Circuit area of Illinois, Indiana, and Wisconsin, it's perfectly constitutional to require teachers and professors to use preferred pronouns. To muddy the waters even further, the Virginia Supreme Court has ruled that it's a violation of both the Virginia Constitution and state laws to force a person to use preferred pronouns. Additionally, in Kansas, though it was only a district court, ruled that the government forcing people to use preferred pronouns is a form of compelled speech and therefore unconstitutional. So what happens now? Well, we continue to have a patchwork of what is constitutional and what is not constitutional until the Supreme Court weighs in on the issue. Since there's a circuit court split, I expect that eventually, rather sooner than later, the Supreme Court will have to address the issue. When? I have no idea. Though I hate to go out on a limb to guess what the Supreme Court will rule in any future case, I'm going to say that they're going to rule that any government entity requiring their employees, including professors and teachers, to use preferred pronouns is a form of compelled speech and unconstitutional. That's my take on the situation. Have a good day.